Welcome to the fifth video in our final pro series so far. Final so far, I say, because we'll have more content rolling out over time. But right now, this is the fifth video of our pro series for consumers and individuals. It's entitled The ABCs of Debt Defense, Part 1, Common Terms, Definitions, and Standards. As always, I'm your course instructor, Attorney Aaron Swift. I'm the managing partner and CEO of Swift Law North. As an agenda, I'm going to start with some disclaimers. We're going to talk about civil lawsuit stages, small claims versus court, outcome options in these types of cases, original versus current creditor and assignments, and then lastly, some legal standards and consumer best practices. Okay, so disclaimer as always, goes to the entire course, but this video and the next several in particular, we want to give specific disclaimers. This is not legal advice. It's only educational. This isn't meant for any one specific person facing a lawsuit or any class of people facing a lawsuit. Certainly, just by purchasing or watching these videos does not mean there is any direct legal advice being given or any direct legal relationship or a lawyer-attorney-client relationship. So let's start with there. This is only educational. Lastly, additionally, check your local and state rules, check with local legal aid, and even check if the courthouse has a self-help resource center. Some even go so far as to have on-staff clerk attorneys to assist for some hourly rates that are pretty reasonable. Okay, so civil lawsuits generally, well, first of all, just to know, and I've had this question, they're not criminal lawsuits. There's no way someone's going to jail at the end of these cases. Well, absent something going way sideways with the judge, and you get held in contempt. But civil lawsuits, there's, at the end of the day, it's about collecting money by way of a judgment and other types of ways. And, there are ways to avoid them. Nonetheless, debt collection lawsuits are filed all the time. They get filed, as you remember, in about 20 to 25% of junk debt buyer files. And that number is just tens and hundreds of thousands across the country every year. Those lawsuits are successful because then 88 to 95% of them end up in default judgments. So, from watching our videos, from participating, from heeding our advice that you are not going to put your head in the sand. You're going to respond to them. And then small claims has different issues where you may have to just appear via Zoom at a pretrial conference, not have to show up. Some small claims you still have to show up. But usually, if you're in small claims, you go through a very quick mediation process. It's a lot more relaxed, even though it doesn't seem relaxed ever. It's scary, of course, to consumers, but it's a lot less formulaic, less procedural than court, where you're going to have some of the same stages that we've talked about in the past, where pre-suit steps, you have a response period, discovery of information going back and forth, and maybe even a trial. But if you're in small claims, it's what's called a hearing, and they're done much differently. So understand, if you are being sued, someone is being sued, just make sure you even know what court system it's in, because the rules on how to reply are different. And then remember, these are civil lawsuits. It's not going to end up in jail. I get that question a lot, and I get how it's scary. Okay, so what are the different outcome options? Worst case scenario, they end up in a judgment. Hopefully not a default judgment. We're going to talk about that in more detail. But a final judgment means the party that filed the lawsuit trying to collect an amount was right, and they're entitled to that amount. Now, they can go about trying to collect that in different ways, get assets via checking accounts, garnish wages, tax returns. But nonetheless, if they get a judgment, they still have to go through steps to collect it. And that can be months and months and months and months and months after one of these lawsuits is filed. Another option is a settlement. As I mentioned, these defendants almost always, because of the metric at stake and the money, they'll accept percentages of discounts. It depends on how old the debt is, the type of debt, even the party. As debt buyers might take less money given what they have into it. So those settlements can often be outcomes of these lawsuits. I'll say look out for what's called a hammer clause, which means if there's a settlement and the consumer misses a payment or defaults or has one delinquency under a new settlement, that automatically the party filing a lawsuit, plaintiffs, is entitled to a judgment, no questions asked. Those aren't good. They shouldn't be signed. There can be recourse, and options if there's a default, but it shouldn't be worst case scenario, do not pass go straight to jail. You have no defenses anymore. The other things, get everything in writing. Whether it's a settlement, whether it's you make payments, anything that you talk about on the phone that you agree to. Certainly, if there's an agreement to delete, because remember, you can do that in circumstances where it's legitimate, but get everything in writing. Avoid judgments at all costs. I'm going to say this so many times in the next several videos. Avoid judgments. Get into a payment plan. Do not get into a default judgment situation where you don't respond or just put your head in the sand. And then lastly, bankruptcy is an option. It may not be the best option for some people. It's certainly not. But if credit repair is not an option, if certainly consumers being sued and has no other choices, sometimes bankruptcy is the best outcome. And a bankruptcy gets rid of these cases, even if they've been reduced to a judgment. A bankruptcy can discharge them. Okay, so I'm going to talk really briefly about original versus current creditors and assignments because these are issues that come up in these cases all the time. Remember, the creditor is the person who allegedly owns the debt at that time. And so that can be an original creditor, like a first party like Discover Bank could be suing a consumer. They were the original creditor, they own it, they have all the paperwork, they can probably prove their case a lot easier. That's the original creditor. But there could be a different current creditor filing these lawsuits. That's usually a debt buyer. Sometimes it's been sold, allegedly sold, transferred several times over. Then there's going to be a current creditor. If there's a current creditor different than the original creditor, no matter how many times, there should be what's called assignments in between each party. Now, there's a lot of misinformation about assignments. I'm not going to go into the law about assignments. It's detailed enough, but just know that these are allowed. There's a lot of phrases in the law I could talk about, negotiable instruments and so on and so forth, but just know that if someone allegedly owns a debt, they generally speaking have the right to sell it. So you hear a lot of nonsense online or these flashy videos making false promises that, oh, assignments are illegal and you never contracted with these other parties, so they can't collect from you, they can't credit report. That's just not simply true as a general proposition. If they've done things right, if the transfers and the sales have gone through right, if there are proper assignments, they can and will collect lawfully and credit report. But nonetheless, those things can and should be scrutinized because often there's problems. So what does that mean? Some legal standards and consumers' best practices. Well, first of all, the legal standard in any civil case is a preponderance of the evidence. Let's just start there. So this isn't like a criminal trial where it's beyond all reasonable doubt. The party that's going to win is going to make it more likely than not they're right. And it's either going to be a jury or a hearing administrator in small claims or a judge in county court. They're going to make a decision ultimately based on the evidence, and that's going to be who's more likely to be right than the other side. And the party who has just barely the preponderance, I kind of talked about on the scale, just one party just barely tips in that favor. That's the preponderance. So that's the standard in these cases. But nonetheless, it's still hard to prevail by some of these defendants, in particular debt buyers often, because they have a hard time proving their paper, which is something we're going to talk about in an upcoming video. So best practices: do not bury your head in the sand. If you've been sued or someone who's been sued, tell them not to. Avoid judgments, especially default judgments. Judgments are so much more powerful than any other type of collection. They can be renewed for a very long time, if not forever. So we want to avoid judgments. Get into a payment plan, get into a settlement if you can. Talk to an attorney. There might be ways to even win these cases outright. We're going to talk about defenses here in a bit. But also contact legal aid and contact bankruptcy attorneys. A bankruptcy attorney, generally speaking, will help you understand if that's the best route for you. And if not, they might help you navigate the defensive case or know someone who will. So if you're sued on a debt you do not owe, that's one of the classic examples. We'd like you to contact us directly. Again, legal disclaimer, we are not giving out direct legal advice. Defensive cases are different. They're not like the FDCPA and FCRA where we can sue all over the country on behalf of consumers. They're very different. You have to be represented by someone in your state if you're going to actually have someone defend you. But nonetheless, if there's very obvious issues like you're being sued on a debt you do not owe, it's someone else's, you settled it, we can help. We'd at least want to be involved, help you, get you in contact with someone that can help in your state. And who knows, there could be an offensive lawsuit that spins off that could entitle you to significant damages. Excuse me. All right, as always, we invite you to participate in more of our educational products and services that can be found at consumerlaw101.com. For more information about litigation, in particular, if you have the idea that someone's being sued on a debt they don't owe, or being sued on a debt that has some egregious violations attached to it, reach out to us at swiftlawnorth.com. Thank you very much.